Welcome to literary and jury charge practice. Let's get started with some jury charge. And the subject of this jury charge is recovery attempt by heir. Heir is H-E-I-R. So somebody inheriting something, it sounds like. Ready? Here we go. She further says that sometime prior to the 7th day of January 1953, at the request of Raymond Swanson, agent of the defendant company, her husband, the decedent, entered into an agreement with the defendant and other individuals whereby he loaned to the defendant certain promissory note executed and delivered to the defendant, payable to the order of the defendant in the sum of $5,000 within 5 years after date. Said note was secured by a mortgage upon this real estate described, which mortgage was conditioned upon the payment of principal and interest of the note. Plaintiff says that this loan was made with the understanding that said note and mortgage was to be deposited with the Superintendent of Insurance of the State of Ohio in order that the defendant might comply with certain requirements demanded by the law of Ohio upon and of corporation of this character. Plaintiff further says that in consideration of the giving of this note and mortgage, defendant agreed that the note and mortgage would be returned to the plaintiff and canceled of record within 5 years of the date of the said note and on or before its maturity. Plaintiff says that it was the understanding of the parties and as part of the consideration for said loan that said note and mortgage was never to be enforced against plaintiff's husband or against the property, and the sole purpose of its execution was to permit the defendant to begin business in the state of Ohio as a duly licensed company. Plaintiff further says that no consideration whatsoever other than the promise of other individuals to loan similar notes was furnished by the defendant for said note and mortgage. Plaintiff further says that the defendant has failed to cause to be released said note and mortgage, although demand has been made of the defendant, alleges that the Superintendent of Insurance will not cancel and surrender the note until the sum of $5,000 with interest has been paid, that there is therefore due from the plaintiff the sum of $5,000 with interest which the plaintiff claims from the defendant. Hopefully your fingers are feeling warmed up. Let's try some literary material now. Ready? Here we go. During my 36-year career so far as a freelance court reporter, I have probably taken more than my share of public hearings. They represent a small percentage of the work my office does, but I raise my hand for such assignments because I enjoy the change of pace these hearings provide. They can be challenging, but they can also be a break from the tension of my other work. I have never been asked to read back or provide real time at a public hearing. Most are held in the evening and rarely go over 2 to 3 hours. And more often than not, I'm given the full 10-day post-hearing comment period to produce a transcript. Also for me, public hearings provide a front row seat for learning about the impact various proposed projects and business decisions may have on our local communities, and I find that listening to the opinions expressed is a very good education in effective and ineffective advocacy. To top it all off, the issues being discussed are often covered by the press, and it's fun when I occasionally turn up in a newspaper photo or in TV footage the next day. Recently, a good client asked my office to report a public hearing being held by a committee of our city council. The subject was a local university's proposal to begin a program of research into biosafety level 4 viruses, for example, Ebola, Marburg, at their facility in a nearby city neighborhood. As luck would have it, the assignment fell to me. I perked up from my deposition doldrums and began preparing for the job. Before actually getting to any hearing, I try to Google everything I can about the controversy, parties, and community involvement. From this research, I create a list of spellings and make up briefs to speed me along, often 20 to 30, with the hope that at least a handful will stick. It's a bonus if I can find pictures of the council or board members who will be receiving the public comment. This shortens my on-the-job face name imprinting process and prepares me in case they ask questions of the speakers. My usual game plan includes arriving at the venue an hour and a half ahead of time. This helps me get the lay of the land and move furniture to my liking without kibitzers. I try to make sure that I'm placed well to see and hear folks at the head table and am near the podium where speakers will make their presentations. I schmooze with the early birds to get a sense of how much public is expected, and I speak with the moderator to assure that I will get a copy of the sign-in sheet. I also ask the moderator to remind the speakers to identify themselves, speak clearly, and provide the court reporter with a copy of any speeches. It's worth a try. All right, let's get back to some jury charge practice. Ready? Now, the defendant has filed a pleading in this case in the way of an answer in which it admits that the American Life and Accident Insurance Company is a corporation doing business in the state of Ohio, that its principal place of business is at Toledo, Ohio. Further admits that the plaintiff was the widow of Henry O. Johnson, deceased, that she is the owner of the real estate described in the petition, and that the estate of Henry O. Johnson was administered in probate court of Lucas County, and that the plaintiff, Marion M. Johnson, is the sole heir of said Henry O. Johnson, deceased. Defendant further admits that on the 4th day of January 1953, that Henry O. Johnson referred to, executed, signed, and delivered to the defendant company a note in the sum of $5,000, payable within 5 years after date. Admits that said note was secured by a mortgage on the property of the deceased as set out in the petition, that said note and mortgage were filed and recorded. It further admits that said note and mortgage were made in conjunction with similar notes and mortgages of other individuals, with the understanding that said note and mortgage, together with the notes and mortgages of other individuals, were to be deposited with the Superintendent of Insurance of the State of Ohio in order that the defendant might comply with certain requirements of law. These admissions just referred to members of the jury. The court will say here, now dispense with further evidence as to those allegations made in the petition of the plaintiff, and for that reason no evidence has been introduced in this case. It may be considered to that extent sufficient evidence. Now then, the defendant, pleading further, denies that it was the understanding of the parties and the consideration given for the said note and mortgage that it would be returned to plaintiff and canceled, and satisfaction entered upon the record as soon as this defendant company obtained funds, or within 5 years of the date of the execution of the note. The defendant further denies that it was the understanding of the parties that as consideration for the giving of said note, it was agreed by the defendant or anybody else that the said note and mortgage was never to be enforced against the plaintiff's decedent, and that the sole purpose of its execution was to permit the defendant to begin business in the state of Ohio as a duly licensed insurance company. Okay, let's get back to our literary. Ready? Here we go. During the hearing, in the small spaces between speakers, I scribble out the words and names I need to check. Then, during any breaks and at the end, I jump from my chair and politely tackle the speakers from whom I need answers before they disappear out the door. For this hearing assignment, it turned out that my normal game plan and expectations had to be scrapped. For reasons not shared with me, our client said I was not actually to be present at the hearing. I would need to report remotely from a live online stream. In addition, he would need the transcript the next day. Oh, and he wouldn't be able to get me a copy of the sign-in sheet. I should just do the best I could with names. I realized that gone would be the routines on which I've always relied. No carefully placing myself in the room, no schooling the moderator on my needs and wants, no ability to get answers to my questions from any of the participants. After some panicking, I checked out online video recordings of previous council meetings. To my relief, at least as far as hearing and seeing were concerned, they were actually surprisingly clear. The camera was instantly on whoever was speaking, and the sound was very good. This would be a major challenge, but perhaps it wasn't going to be impossible. I elected to record the live stream at our client's office rather than from home. If there were to be any technical glitches, I wanted someone from the law firm present to acknowledge the problem and get things back on track. The hearing was to start at 4 p.m. We were told it might go as late as 10 p.m., but I assured myself that they always overestimated these things. With the few breaks they would surely take, I felt that I could handle whatever happened. My husband normally transcribes about half of my work. The plan was for me to bring the job home when it finished. We'd divide it in two, and each of us would work into the night and the next day to get it edited. He took an early evening nap to be ready. At the client's office, an IT person pulled up the City Council's streaming site and projected it onto a large wall screen. He set a pitcher of water and a glass in the middle of the table and pointed out the location of the restrooms and vending machines, at which point, to my raised eyebrows, he left for the day. The attorney who hired me turned out not to be present either because he was actually attending the hearing. His secretary popped her head into the room to make sure I was set up, and she was going home at 5 p.m. and asked me to turn everything off when I left. My chin quivered a bit as I realized I was completely on my own after all. Back to some jury charge. Ready? Defendant further pleading says that his note and mortgage was given by the plaintiff's husband in return for stock in the defendant company in the sum of $5,000, that the records of the defendant company at this time show that this stock is now held and is in the possession of plaintiff. Defendant says that plaintiff has sold a portion of her stock and the balance she now holds, that this stock in the sum of $5,000 was issued to plaintiff's husband and that the stock was the consideration for the giving of the note and mortgage as described in plaintiff's petition. The defendant denies that it now has or at any time has had sufficient funds to deposit with the superintendent of insurance. We will not release, cancel, or return the note and mortgage as set out in plaintiff's petition. Denies that there is anything due to the plaintiff in any sum whatsoever. The second cause of action, pled in plaintiff's petition and referred to by the second defense in defendant's answer, are not for your consideration, members of the jury, and you will have nothing to do with it. Well, that finishes up that jury charge. And it looks like we have another one with the same subject. So it must go on. So let's see how this one goes. Ready? So these pleadings, members of the jury, make up the issues. By the way, this answer of the defendant has called for a further pleading on behalf of the plaintiff in the nature of a reply in which plaintiff simply denies each and all the allegations and statements made and contained in defendant's answer, which are neither denied nor admitted in plaintiff's petition. So it is from these pleadings, members of the jury, together with the evidence in the case, that we determine the issues. The issues are the disputed questions of fact and are for you to determine from the evidence under the law as given you by the court. Now, as you have already sensed from the reference to the pleadings, this is an action seeking to recover the amount of $5,000 and interest, represented by a note and mortgage executed by Henry O. Johnson and delivered to the plaintiff for a specified purpose, as claimed by the plaintiff, to wit, to be deposited with the superintendent of insurance to establish or to help establish the necessary fund to qualify the defendant company to proceed with its proposed issuing of policies of insurance upon the lives of individuals. It is claimed by the plaintiff that there was an agreement between her deceased husband and the defendant company that within 5 years this note and mortgage was to be returned, canceled, and satisfaction entered of record. Defendant denies this claim of the plaintiff and alleges that the note and mortgage were given by the plaintiff's deceased husband in payment for stock in the defendant company, and that the delivery of stock was and became the consideration for this note and mortgage, and in effect claims that it thereby became a closed transaction and that they owe the plaintiff nothing. And that will conclude our literary and jury charge practice.